Hello everyone. In our last video we looked at the basic way to form a valid contract and the elements that were needed. An offer, an unqualified acceptance of the exact offer, and some consideration. Meaning, I promise to sell you my car for $500, I promise to pay you $500, we have a meeting of the minds, we're talking about the same vehicle, and we have a valid contract. In spite of those particular elements, there are certain occasions that will lead a court to declare there is no contract, or to declare that a contract can be voidable, which we'll talk about in a second. And those are just the little quirks that are other elements that can affect the validity of the contract. And we're going to look at 6 of them today. The first of these is capacity. You can enter into a valid contract, such as the one I just suggested, but the assumption for that contract to be valid is that both parties have capacity. Now, what do we mean by capacity? Well, if you are under 18 in most states, for most contracts, you do not have capacity to enter into a contract. Minors are not permitted to. So what happens if you do? If someone is 30 years old and they're online and they're looking to sell a laptop computer for $100, and you're a 17-year-old and you're also online and you enter into a contract, I'm going to buy this computer from you for $100 or whatever, is there a valid contract? There is a valid contract, except the party without capacity can ask the court to void it, but not the party with capacity. So, 17-year-old says he wants to buy a computer from a 30-year-old. They enter into what they believe is a valid contract, and then the 17-year-old doesn't buy it, and the 30-year-old sues. The 17-year-old can ask the court to void the contract because he doesn't have capacity to enter into a contract in the first place. And in most jurisdictions, the 17-year-old will prevail. It is voidable. On the other side of things, let's say they enter into this contract and the 17-year-old buys the laptop and it's not what the 30-year-old represented it to be, or it's broken, and they can't resolve it on their own, so the 17-year-old sues. Can the 30-year-old say, well, we didn't have a valid contract to begin with because he didn't have capacity, he was underage? No, he can't. The court will consider the contract valid. So when we're dealing with issues of capacity, do you have the capacity to enter into a contract? The party who does not have capacity, for that party, it is a voidable contract. So the law is trying to make sure that you don't take advantage of people who do not have capacity to enter into contracts, because it can be voided at their request, but not at yours. There are a few other categories of issues that go to capacity. For instance, an individual might not have the mental capacity to understand the actual terms of the contract. They may be having psychological episodes of mania or delusion and be declared to really not have capacity to enter into a contract. In all of these cases, you're not of sound mind or body, you're not of age. That contract is voidable. A third subpart of that would be if a party to a contract is intoxicated. And the courts they kind of weigh on both sides of this issue. On the one hand, if you are, many contracts are signed in a tavern, and they have been for years, and people are drinking. On the one hand, the courts do not want to reward your excessive drinking by allowing you to get out of it and saying, well, I didn't have capacity because I was intoxicated. So that alone will not enable you to get out of the contract. The flip side of that is the law also does not want someone to take advantage of another party. So if you know darn well that the other party is completely intoxicated and you're sober and you're going in to make this deal, it will be voided if you have taken advantage of the other party. So if you're both at the tavern and you're both drinking, you're having a celebration because you finally signed your contract, that's a valid contract. You can't try and get out of it by saying, well, I was under the influence. If one party is seeking to take advantage of another, then that contract will be voided. So in all of these capacity cases, the contract is voidable depending on the circumstances and depending on who is taking advantage of someone else. That's the first broad category of issues that might affect a contract's validity. The second is duress. If you sign a contract that you normally would not want to sign or really not be happy with the terms, but you feel pressured or even threatened or afraid because of what the other party is doing, that is duress. And if someone says to you, you know what, you're going to sell me this piece of land, or you're going to sell me this car of yours, and if you don't, well, you know what, I'm going to start complaining to the town boards, and I'm going to file this lawsuit against you, and I'm going to do this, and I'm going to do that, that's duress. And if you enter into that contract, you will be able to get out of it. It's voidable because of the duress the other party put on you. Now, if you want that contract to go through, the other party cannot void it. They can't say, well, I put that person under duress, so get me out of the contract. That's not going to work. This is a voidable contract, and once again, it's all geared towards protecting the weaker party and not allowing the stronger party to get away with something. A third reason a contract might not even be recognized as existing is if it is a contract that requires a written document. And there's not a lot of these, but there is a common law concept called the Statute of Frauds. And the Statute of Frauds, which doesn't have to do with what you might think of when you hear the word fraud, the Statute of Frauds, this concept says that certain transactions are so important that we must have the terms in writing. Across the United States, any contract for the sale of real estate must be written. No matter how much you've talked about it and how much you're in agreement, and even if you both agree that you entered into this verbal contract, the courts will say no contract exists if it's not written, if it's a sale of real estate. The different 50 states have also added a few other scenarios that come under the Statute of Frauds. Some states will say that if a contract cannot be carried out in under a year, it must be in writing. And part of that is to protect the process because after a year, memories fade and people forget what the exact terms were. So if it's going to take more than a year to carry out this process, then it needs to be in writing. Many states also have a dollar limit. If it's a contract for a sale of goods that's over a certain dollar amount, $500, $5,000, that might have to be in writing. And that's the result of a specific statute passed by a specific state. As I said in the beginning, in our last video, contracts do not have to be written as a general rule, but there are certain exceptions, and these are those exceptions. Fourth, a contract is only valid if it is valid for legal purposes. So for instance, if I say, I promise to sell you this bag of cocaine if you'll pay me $1,000, and you agree to it, and we have a meeting of the minds, the court will act as if no contract exists, because the sale of cocaine is not a legal purpose. It can also involve something such as an employment contract. If you're in a state that does not permit legal gambling, and you say to someone, I will hire you as a blackjack dealer and pay you this amount, and then I hire you and don't pay you, good luck suing me for damages. This is a case where the contract is not voidable at the behest of the harmed party or the weak party. A contract for goods or services that is illegal or for a illegal purpose doesn't exist. It is void completely. There is no contract. So don't think that entering a contract is going to do anything for an illegal purpose is going to do anything except make a good movie scene, because it will not be enforced, it will not be recognized. The fifth, and this is kind of related to what I just said, is if there is a fraudulent misrepresentation in the terms of the contract while it's being made. In other words, the contract is for a perfectly legal activity or good, but one of the parties makes a fraudulent misrepresentation. And a good controlling case on this from 1998 is Campbell v Clark, which is an Indiana case. In Campbell v Clark, Campbell had purchased 2 lots of land, vacant land, on a lake, which he intended to build a house on. Turns out he was unable to build a house on that land because when they did all the septic tests, tested the soils, the land was completely unsuitable for a septic system anywhere on the land. So he decided to sell the land. He offered it for sale, and the de Clarks went to him, toured the land, told them that they had intended on putting a house up. What a beautiful location for a house. Mr. Campbell didn't say anything. He argued later in court, well, they didn't ask me anything about the septic or about the suitability for a house. They just told me that they were thinking of building a house. Well, it turns out during the testimony that the de Clarks asked him, well, why didn't you build a house here, and where are you going? And he said at the trial, well, I decided I wanted to move to another state. I wanted to move to Minnesota. All my friends are there. That was the response he gave them. That was considered a fraudulent misrepresentation. He had material knowledge of a problem with the land. He knew that the buyers were buying it for a purpose, or at least had a specific purpose in mind, and he did not divulge it. In that case, the de Clarks asked for their deposit money back and didn't want to go through with the deal. And the court said, yeah, that's right, because you didn't have a contract because there was a fraudulent misrepresentation in the negotiations for the signing of the real estate deal. So there are your 5 most common reasons that a contract that seems to have all the elements, acceptance, offer, consideration, might be voided or voidable by the courts. Capacity, duress, the need for writing and the Statute of Frauds, legality of the good or service being contracted for, and fraudulent misrepresentations during the course of the negotiation for the good. Now we're going to get to what is probably the most important of these, and is becoming a bigger and bigger area of the law, and is one of those places where the little guy gets a hand up from the court. And it's a case that goes back to 1947 called Campbell V Wentz. Absolutely awful fact pattern There are no good guys in this case, and so I'm going to take you step by step through what happened in this case. In Campbell v. Wentz, Campbell is the Campbell Soup Company that you're all familiar with, a New Jersey corporation. And Mr. Wentz was a farmer in Pennsylvania. Now, if you've ever had a can of Campbell vegetable soup, or even chicken noodle soup, you may or may not have noticed the carrots. They're cut in perfect cubes. They're bright reddish orange. And it's not because Campbell puts food dye in it or anything like that. It's because back in the 1940s, a carrot was developed called the Red Cord Chantenay No. 5. That was the name that was given to it. And Campbell Soup Company fell in love with this carrot. They were very hard to get because they were blocky, meaning they could cut them into cubes, and they were bright red. And that's the only carrot they wanted for their signature brand soups. Red Chantenay No. 5. So, Campbell Soup Company began breeding these carrots and collecting seeds, and they contracted with Mr. Wentz to grow carrots for them for Campbell Soup. They provided him with the seeds, and the contract stipulated that he was to grow the carrots and then at the end of the season sell them back to Campbell at a price of $30 a ton. Mr. Wentz agreed to this, took the seeds, planted the carrots, harvested them. But then Mr. Wentz decided that $30 a ton wasn't a good enough price. And in fact, these carrots were in high demand by many soup companies. And in the market price was actually $90 a ton at the time of harvest. So Mr. Wentz told Campbell that his crop failed and he didn't have any, and he sold the carrots to his neighbor, who then turned around and sold them to Campbell at a higher price. And of course Campbell needed these carrots, so they bought them. It didn't take long for Campbell to figure out what was going on here, and they sued for breach of contract. When they went to court, and we've discussed the difference between going to an equity at law, meaning you get money damages, or a remedy at equity, meaning you get specific performance. Well, Campbell Soup Company didn't want money damages. They said, money's not going to help us. We can't find these carrots on the open market. We want specific performance. We want Wentz and his neighbor to deliver those carrots that we provided the seeds for immediately. They lost. Campbell lost at the trial court level. And the trial court said that you could just get money damages, a carrot's a carrot. Campbell was incensed, and they appealed, and it went to the Third Circuit Appellate Division. What happened at the Appellate Division was really monumental in terms of contract law. The Circuit Court held that, yeah, you know, specific performance might be possible in this case if the Red Chantenay No. 5 carrot was really that unique. However, in spite of the fact that these two entities had an offer, an acceptance, and a contract, in spite of the fact that Mr. Wentz flagrantly breached the contract, we're not going to enforce it. And the reason they gave was that the contract, in their view, was unconscionable. And that's the term that was used, and that is the legal term that is now used in certain contracts. The court went back through the contract, and they said, look, Campbell and Wentz did not have any ability to negotiate. They didn't negotiate this, they didn't talk about it, they didn't look at different elements. Campbell basically gave Wentz a contract and said, this is our contract for farmers growing our carrots or our seeds. Sign it. Take it or leave it. In the contract, it said that the Wentzes had to grow the carrots at a certain rate per acre. That they had to, after they harvested, they had to cut the tops off, they had to have them perfectly cleaned, they had to put them in certain types of bags, and they would all be delivered to Campbell. The contract gave Campbell the right to reject any of the carrots that they said did not meet their standards, and the contract also said that if they rejected these carrots, Mr. Wentz was not allowed to resell them to anyone else on the open market. When the court looked at all of the clauses in the contract, the court decided this is absolutely unconscionable. The entire contract is geared towards protecting Campbell's interests and not protecting any of the farmer's interests. And so even though it's a valid contract, we're not going to enforce it because it's unconscionable. This was a very controversial case. It still is a controversial case because, as I said, there are no good players in this fact pattern. However, modern courts have begun to tailor that and refine it a little bit. A contract, when a large corporation, could be an insurance company, could be an auto dealer, could be a financial institution, when they have form contracts that go on for pages and pages, and you've probably seen these, and you aren't really given the opportunity to change the terms. I'd like to strike that paragraph. I'd like you to retype paragraph 320. When the other party doesn't have that capability, this is now called a contract of adhesion, or an adhesion contract, because it means that one party has to adhere to all of the terms the other party presents, and there's no ability to counteroffer or negotiate. In an adhesion contract, they are valid. They will be enforced. However, any clause in an adhesion contract that appears to be unreasonable, that a reasonable person would not expect to find in that contract, that's not industry standard, that was just like another way to protect the writer of the contract, the corporation, rather than the person signing. The clause may not be enforced against the little guy because it's unconscionable to do so. Is this a matter of a court's opinion? Sure. Is it very inexact? Yes. Is this why in the very first video I made for this class, I said people are always asking, well, what is the rule in this case? What is the law? And I responded with, don't know. That's because even though all of the contract provisions are in place, everyone's agreed to them, there are conditions under which the stronger party will be held to a stricter standard than the weaker party, especially when the contract is full of endless words and paragraphs that the weaker party may not fully grasp, understand, or even read at the time they sign. So, with this lesson, we're going to look at another pretty wacky fact pattern in a video that I'm posting to the site, and I'm going to ask you to apply all 6 of these principles to the negotiations that take place in this video. And you tell me if there's a contract or not. And if there is a contract, is it voidable or not? Tom Simmons, see you next week.